A contract is binding, and agreements must be kept, right? Ancient texts like the Bible make reference to contracts. Abraham had an agreement with King Abimelech that allowed the former to live in his kingdom and make use of a well. In return, Abraham would give the king sheep and cattle. Back then, as now, a contract required that at least two parties actually agree to it. That means the parties to the contract have to agree to accept its terms. When both sides stand to profit and the deal is made, the contract is sealed, either with an oath, in writing, or with a handshake. From a legal point of view, in many countries, these methods are equally binding. Even today, cars and horses are often sold with a handshake. That requires a lot of trust, a prerequisite for any contract, regardless of what it relates to. Whether it's a contract for a house, a tenancy agreement, a work contract, a lease, repair contract, or a marriage contract, trust and confidence are crucial. The principle that agreements must be kept, or pacta sunt servanda in Latin, is based on the notion that honest people will do the right thing and abide by a contract, even if it leads to negative consequences in the future. That applies to nations as well. Governments aren't supposed to break international contracts by means of national legislation. That's the principle of customary international law. Nevertheless, contracts are often broken. Parties in breach of contract can end up in court. A judge can then force them to fulfill its terms or pay a penalty. Other consequences could be dismissal from a job or being shut out of future deals. In the criminal underworld, a breach of contract can mean more than a fine. People who go back on a promise made to the mafia might find themselves wearing cement overshoes. Call it honor among thieves, but even in organized crime, agreements must be kept.